विद्यार्थियों, फर्स्ट ऑफ ऑल इस कोटेशन के बारे में हम आपसे चर्चा करेंगे। उसके बाद फिर हम जब क्वेश्चन सॉल्व करेंगे तो आई स्पीक ओनली इंग्लिश। जिंदगी की लगातार मिल रही असफलताओं से निराश नहीं होना चाहिए। प्री दिया, एक आध दो बार हो गया, 3 बार हो गया, नहीं हुआ, वही चीज है। जिंदगी में लगातार मिल रही असफलताओं से निराश नहीं होना चाहिए। कभी कभी गुच्छे की आखिरी चाबी भी ताला खोल देती है। यानी जो लास्ट चांस है, चौथा जो अटेम्प्ट है, वह अधिकारी बना देता है। ये चीज यहां पर कही जा रही है। इट मीन्स द फोर्थ अटेम्प्ट टू अपीयर इन PCSJ एग्जामिनेशन make you an officer. Now we start. The first question: the draft of Indian Evidence Act. The draft of Indian Evidence Act 1872 was prepared by. It means who prepared the document of the Indian Evidence Act? Who prepared? I have taught you in 15 March 1872 the Indian Evidence Act was enacted and it was enforceable in September 1st, 1872. It means the draft. It means the Indian Evidence Act 1872 was enacted by the legislature in 15 March 1872 and it was enforceable 1st September 1872. But here the question is asked from you that who drafted the Indian Evidence Act? Who drafted? Sir James F. Stephen has drafted. It means Lord Macaulay, undoubtedly he was appointed as a law minister, but the Indian Evidence Act was drafted by the Sir James F. Stephen. So the correct answer would be B. Next question: who drafted the Indian Evidence Act? It is just like the first question, so it is obvious. J.F. Stephen drafted the Indian Evidence Act. It means Sir Stephen drafted the Indian Evidence Act 1872. So the correct answer will be J.F. Stephen. Next, question number 3rd. Which of the following statement is correct in relation to Indian Evidence Act? It means under 4 options, which option is correct? We start. Sir Henry Maine prepared the draft bill of the act. Sir Henry Maine prepared the draft bill of the act. It is wrong. I have told you the draft was prepared by the Sir J.F. Stephen. So A is incorrect. B. Sir James Stephen prepared the draft bill of the act. Next, the draft bill of the act was prepared by Second Law Commission. Second Law Commission. But who is the chairperson? Who was the chairperson of the Second Law Commission? Here it was not told. So, obviously we can say that second, it means B option is correct among these. And which of the following statement is correct in relation to Evidence Act, Indian Evidence Act? Option B is correct among these. So B, correct answer is B. Next, question number 4. The law of evidence under Indian Evidence Act 1872 is a substantive law, is a procedural law. Substantive and procedural law, the both it means. And the fourth option is none of the above. It is a technical question. Which option is correct? If you study the Indian Evidence Act thoroughly, you see that generally Indian Evidence Act is a procedural law. At some portion, some part, but you can say that some sections are relating to substantive law. For example, section 115. Section 115, doctrine of estoppel, is relating to the substantive law. So, if you thoroughly study about the Indian Evidence Act, you see Indian Evidence Act have the both nature, substantial as well as procedural. But which option is correct? If it is asked from you, so which option is correct? Substantive law, undoubtedly it is incorrect. There is a confusion between B and C option. B says that procedural law, whereas C says that Indian Evidence Act is a substantive as well as procedural law. The both attributes undoubtedly are found in Indian Evidence Act. So, the correct answer, which is correct according to the commission and in whole soul, the nature of the Indian Evidence Act is a procedural law. Why? Because it has retrospective effect, and if an act has retrospective effect, that act shall be regarded as a procedural law, not a substantial law. Note it down. It means law of evidence, the Indian Evidence Act 1872 is regarded as a procedural law, not a substantive or substantive and procedural law. So the correct answer would be B, option B, procedural law. Section 115, on the basis of section 115, it cannot be said the Law of Evidence Act or Indian Evidence Act 1872 is a substantive and procedural law, because the whole soul nature of the Indian Evidence Act is a procedural law. So the correct answer, the correct option shall be B option. This is correct. And the next question, question number 5. Law of evidence is the same, a substantive law, an adjective. Adjective law means any act which is a procedural nature, which is a procedural act law, that is called adjective law. It means if any act is an adjective law, that act shall be regarded as a procedural law also. So option B, it describes, it says that law of evidence is an adjective law. Why? Because it is a procedural law. I have told you, a procedural law has retrospective effect. So option B is correct in this question. Option B is correct. Adjective means procedural law. Adjective means procedure. If any act is said that act is an adjective law, it means that act shall be called an adjective law. It means that act shall be called a procedural law also. So the option B is correct, not C. Question number 6. Next question. Question number 6. What does say? Indian Evidence Act 1872 applies to. Indian Evidence Act 1872 applies to. It means where Indian Evidence Act shall apply only civil proceeding, only criminal proceeding, only civil proceeding, only civil proceeding, only criminal 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 proceeding, only civ civil as well as criminal proceeding? D. None of the above. When we study section 1, undoubtedly section 1 of Indian Evidence Act describes short title, its extension, and where it applies. Three things you can say is propounded in the section 1 of Indian Evidence Act. Here the question, Indian Evidence Act 1872 applies to. I have told you, section 1 explains three things. The first one, short title. The second one, extension. The third one is where it applies. Directly we come on the topic where it applies. It applies to all proceedings of the court except arbitration, and it also does not apply to the affidavits presented in the court. Here proceedings, all types of judicial proceedings. So all types of judicial proceedings mean civil as well as criminal. Civil and criminal, the both type of judicial proceeding shall be included in it. It means here we come to question only on civil proceeding. Only on civil proceeding. I have told you it applies. It means law of Indian Evidence Act 1872 shall apply to all type of judicial proceeding. It means Indian Evidence Act shall apply not only to civil proceeding but it also apply to criminal proceeding. So the best option, correct option is civil and criminal proceeding, the both. Why? Because Indian Evidence Act 1872 applies on the either proceeding. What is the either proceeding? It means civil as well as criminal proceeding. The both proceeding of court, it means judicial proceeding, Indian Evidence Act shall apply. Okay, so the best answer, the best option is C of this question. Indian Evidence Act 1872 applies to civil and criminal proceeding, comma, the both. Okay, next question we start. Question number 6. After it, next question, question number 7. Indian Evidence Act applies to both civil and criminal proceedings. Okay, before a court is the statement Indian Evidence Act applies to both civil and criminal proceedings before a court is the statement not correct? It means the statement is correct or true. The statement I have told you, Indian Evidence Act applies to all type of judicial proceeding except arbitration. It means it applies to civil as well as and criminal proceedings of the court, in a court or before a court. So the statement is true. According to section 1, it is clearly mentioned. It has been clearly mentioned, obviously mentioned, that the Indian Evidence Act applies to civil proceedings and criminal proceedings. So the best answer is correct. It means B. Best answer B. The statement is correct. It applies civil and criminal, the both. Next question, question number 8. Law of evidence. Law of evidence. Retrospective effect. Affect the fundamental right of person. Always have prospective effect. Not a procedural law. ये और ये तो बिल्कुल गलत है. The both option totally wrong. Here A and C is a considerable. Now the nature of the act is of two types, or you can say directly that the law is of two types. The first one, procedural, and the second one is substantive. The second one is substantive. Substantive law has a special character that it has prospective effect. Generally, substantive law has a prospective effect, whereas procedural law has a retrospective effect. So, Indian Evidence Act is a procedural law. Hence, or since Indian Evidence Act is a procedural law, so it has a retrospective effect. The law of evidence contains a retrospective effect. So the best option is A among these. Why? I told you Indian Evidence Act is a procedural nature. Since Indian Evidence Act is a procedural nature, generally a procedural act has the specific character. What type of specific character? It contains a retrospective effect. Since Indian Evidence Act is a procedural act, so it has retrospective effect. Here the option is A. That is correct. Next question, question 9. Point out the correct answer. What is the correct answer? It means the question is not complete because we are solving the questions relating to Indian Evidence Act. So it is said about the Indian Evidence Act. Point out the correct answer in reference in the context of Indian Evidence Act. Okay. It means lex talliens, lex fori, lex loci, lex citus. Indian Evidence Act, what type of act? Lex talliens, that is wrong. Lex fori, lex loci, or lex citus. Indian Evidence Act is a lex fori because where any trial is conducted, law of evidence or the law of evidence shall be applicable of that particular area, that particular state. So Indian Evidence Act is a lex fori. The correct answer is B. Here option B is correct. Indian Evidence Act is lex fori. It means where any fact in issue is decided by the court, the evidence of that rule of evidence of that country shall be applicable. So it is a lex fori. And the correct answer is B. Next question. The meaning of lex loci. What is the meaning of lex loci? Lex loci means particular area, particular land, territory. So particular land, it means law of the land is supreme. Here lex loci means, what is the meaning of lex loci? So the correct answer what would be? The first one, law of the land is supreme. Law of land, local laws, and law of England. Here the correct answer is law of land. It means particular land law. The law of particular land shall be applicable. It means if any act is said that the act is lex loci, it means the law of the particular land shall be applicable. For example, personal law, Hindu or Muslim, these laws are lex loci. Where Hindu or Muslim of the nation of the India, if they go anywhere, personal law of India shall applicable to them. So the correct answer is B of the question. question. Next, question number 11. The Indian Evidence Act 1872 has been divided into parts and chapters. How many parts? How many chapters? How many sections? Indian Evidence Act 1872 contains 3 parts, 11 chapters, and 167 sections. According to it, the correct answer, parts 3 and chapters 11, it means option B shall be correct. Next question, question number 12. How many sections and chapters are there in Indian Evidence Act? How many chapters? I have told you just before. Indian Evidence Act has 3 chapters, 11 has 3 parts. There are 3 parts in Indian Evidence Act. 11 chapters, 167 sections. So, sections 167, chapters 11. This is the correct answer. It means option C. Option C is correct. It is a ready-made question, not a technical. So, question number 13. As per preamble of the Indian Evidence Act 1872, the purpose of this act is. What is the purpose of the act? What is the purpose of the act? Here we see that when we study preamble of Indian Evidence Act, it is said that whereas it is expedient to consolidate, define and amend. These 3 words are used. Consolidate, it means to collect, to assemble, define and amend. Law of Indian Evidence Act. Law of Indian Evidence Act. It means it was enacted for the purpose. What the purpose? Here mentioned that consolidate, define and amend. These three words should be contained. So the best option, consolidate, define, amend the law of evidence. It means I have told you, in the preamble of the Indian Evidence Act, it was mentioned that whereas it is expedient to consolidate, define and amend the law of evidence, hereby it is enacted. It means law of evidence or Indian Evidence Act for the purpose define and amend Indian. So the best option is D. The best option B. D. D. D the best option. Next question. Question number 14. The Indian Evidence Act applies. The Indian Evidence Act applies to proceedings before tribunals. Okay, this is wrong. All judicial proceedings. It was mentioned in the section 1 of Indian Evidence Act 1872. Judicial proceedings. So it is not correct. Affidavits presented to any court or officer. It is also not correct. Proceedings before and arbitrator. It is also not correct. So here the correct answer shall be D. The correct answer shall be D. Students, look here. What is the question? The question is, the Indian Evidence Act applies to. Where the Indian Evidence Act applies? I have told you in section 1 of Indian Evidence Act, three facts are mentioned. The first one is short title. The second one is extension of Indian Evidence Act. And the third one is where it applies. I have told you, Indian Evidence Act applies to all proceedings, all judicial proceedings. It means whether it is civil or criminal or procedural, any type of proceedings, but it must be judicial, not of any other. So all type of judicial proceedings, the Indian Evidence Act shall apply. And in this context, the best option, the best answer of this question shall be D, option D. It is correct. Next question, it means question 15. What does say? The Indian Evidence Act applies to affidavits, wrong. Judicial proceedings, it is correct. Arbitration proceeding, it is incorrect. All of these, it is also. The Indian Evidence Act applies to, I have told you, all judicial proceedings. All judicial proceedings, it applies. So the option shall be B. Option B shall be correct. Because under section 1 it was explained, Indian Evidence Act 1872 shall apply to all judicial proceedings. All judicial proceedings. And further it was said that it shall not be applicable to affidavits presented before the court or proceedings before arbitrators. So it is obvious the Indian Evidence Act shall applicable only to judicial proceedings, whether civil or criminal. The both type of proceedings the Indian Evidence Act shall apply. The next question, question number 16. Question number 16. The Indian Evidence Act 1872 applies to, where it applies? Where it applies? Administrative tribunal proceedings. I have told you, no tribunals. Indian Evidence Act shall not apply to any tribunal. It applies only judicial proceedings. So it is correct. So it is false. Arbitrators proceeding, it is also wrong. Contempt proceeding, it is also wrong. So none of the above. The question is where the Indian Evidence Act 1872 applies to. Where it applies? Indian Evidence Act shall apply only judicial proceedings. Only all type of judicial proceedings, where it is procedural or criminal. The both type of proceedings the Indian Evidence Act shall apply. So the best answer shall be D. The best answer shall be D. Next question. (17) Which evidence is not admissible? Which evidence is not admissible? It means which type of evidence is not accepted, is not admitted in the court. Come to the point. Evidence of affidavit, it is wrong. Oral evidence, correct. According to the question, not admissible, not. Emphasize, not. It means if you see the term not that is used in question number 17, which evidence is not admissible? This is the question. Not admissible. Admissible nahi. Not admissible. It means which type of evidence is not admitted. So which evidence is not admitted by the court, the answer shall be correct. If you see that oral evidence is admitted, documentary evidence is also admitted, expert evidence, any expert opinion that is given under section 45, so it is also admitted by the court. But the question is not admissible. It is not admissible, so the correct answer shall be evidence of affidavit. It is not admitted by the court, so the correct answer shall be A. Next question, question number 18. The Indian Evidence Act 1872 applies where all judicial proceedings in or before any court, affidavits presented to any court or officer, where the term affidavit is used, that option obviously shall be incorrect. So B option is incorrect. Proceeding before an arbiter, it is also incorrect. Here the best option shall be A. All judicial proceedings in or before any court. If you see that any court, the term is used, but arbitration court, it is not applicable. If you generally see that all judicial proceedings in or before any court, in general, it is true. But here the term any is used. If you focus the term any, then it shall be also incorrect. Why? Because arbitration court, it shall not be applicable. If any proceeding is conducted, is run in arbitration court, the Indian Evidence Act shall not be applicable. Here the term is used any. So if you focus the term any, it is incorrect, and if you see it in general, it is correct. The Indian Evidence Act, undoubtedly, if you focus the question, study again. The Indian Evidence Act 1872 applies to all judicial proceedings in or before any court. Under section 1, it is mentioned that the Indian Evidence Act shall apply to all judicial proceedings in or before any court except arbitration's judicial proceeding. It means arbitration judicial proceeding. And if you see that what is court, here the term is court is used. What is court? Section 3 defines the court. Section 3 of Indian Evidence Act defines the court. And according to the definition, it means section 3. The court includes what? All judges, all magistrates, and all the persons except arbitration authorized by law to take evidences. This is the definition the court that is mentioned in the section 3 of Indian Evidence Act 1872. It means if the term court is used, arbitration shall be excluded automatically. It means arbitration shall not be included in the court. So, the best option is A. If you study in broad, you see that court does not have the term arbitration. According to the definition of the court mentioned in the section 3 of Indian Evidence Act, because under section 3 of the code, the term court is defined, and it was mentioned that the court includes all judges, all magistrates, all the persons except arbitration legally authorized to take evidences. It means in the term court, arbitration is not included. So the best option shall be A. Okay. Next question. Question number 19. Question number 19. Select the incorrect statement. Incorrect. If any term is used in Indian Evidence Act, or you can say if any term is used in the question, not, incorrect, correct, so what type of term is used, you must see, you must be careful about these words. So here incorrect, we have to find out the incorrect statements. Which statement is incorrect? See that the Indian Evidence Act does not apply to arbitration proceedings. It is correct. The Indian Evidence Act does not apply to proceedings before commissioner appointed by the court for recording the evidence. It is also incorrect. The Indian Evidence Act, it is correct, the first one is correct. The Indian Evidence Act applies to affidavits presented before the court. It is also incorrect. The Indian Evidence Act applies to judicial proceedings held before all kinds of military courts. It is also incorrect. It means the first one is correct. And 2, 3, 4, these are incorrect. These are incorrect. And the first one is correct. So, if you see that, select the incorrect statements using the code given below. It means incorrect statement you have to find out, and A, B, C, D, these are 3 options. See that 1 is correct, and except 1, 2, 3 and 4, all these are incorrect. So 2, 3, 4 are incorrect. The A, 2, 3 are incorrect. I have told you not only 2, 3 but also 4 are incorrect. So 2, 3 and 4 are incorrect. The option B is correct of the question. Option B is the most appropriate answer of the question. Question number 19. Next question, question number 20. Which of the following statements is not correct relation in word and expression used in section 3 of Indian Evidence Act? What I said? Fact includes not only state of things but also mental condition. It means section 3 of Indian Evidence Act defines the term fact. What is fact? Actually, it does not define the fact. It classifies the fact, section 3, and it was mentioned that facts are of two types. The first one is material. The first one is material fact. And the second one is mental fact. The first one is material fact and the second one is mental fact. What is material fact? Material fact means things, anything, state of things, relation of things. Things, state of things, relations of things that is perceived by the senses, which are perceived by our senses. This is the definition of material fact. Whereas, what is mental fact? Clause B, mental fact, is also defined under section 3, and it has been mentioned that mental fact means anything, any mental condition of which a person is conscious about things, of which a person is conscious, that is called mental fact. Here, which of the following statement is not correct? It means we have to find out incorrect answer. Not correct is meant in incorrect in relation of word and expression used in section 3 of the Indian Evidence Act. So which of the following statements is not correct? Fact includes not only state of things but also mental condition. It is correct. Next, court includes arbitrators. No, it is incorrect. An inscription on a stone is a document. It is a fact. It is true. True. A fact is said to be not proved when it is neither proved nor disproved. Under section 3rd, 3 words, those are defined. The first one is proved, the second one is disproved, and the third one is not proved. Here the four option contains not proved. What is not proved? If any fact is not proved by the evidences nor disapproved by the evidences produced in the court, that fact shall be called not proved. The definition of not proved is true. Not proved is true. So it is also true. So here the wrong answer shall be B. B is the wrong answer. The option shall be B. Okay. Next question. Question number 21. Which one of the following is not judicial proceeding? Under these options, judicial proceedings are mentioned, but any of them that is not a judicial proceeding. So which option explain about not judicial proceeding? The first one, hearing by a judge. It is a judicial proceeding. Hearing by a person who is authorized to take evidence. It is also. Hearing before an arbitrator. It is wrong. Why? Because Section 3 defines court, and in the definition of the court it has been mentioned that court includes all magistrate, all judges and all persons authorized by law to take evidences except arbitration. It means arbitration is not included in the court, in the term court. And here it is mentioned, it is in writing, hearing before an arbitrator. So this, the option is wrong, C. And in the question it is asked, which one of the following is not judicial proceeding? A is a judicial proceeding, B is also judicial proceeding, D is also judicial proceeding, but the option C, that explains about the non-judicial proceeding. So the option C shall be correct. The correct option, the correct answer of the question is mentioned in the option C. Okay? So you have to answer C. Next question, question number 22. Which one of the following terms has not been defined by the Indian Evidence Act under Section 3rd? It means under following options there are given some terms, and Section 3rd of Indian Evidence Act is connected with interpretation of the interpretation. And here the question, which term is not defined in the Section 3rd of the Act? Which term is not defined? If you see, court is defined, document is also defined, evidence is also defined, But confession is not defined in the section 3rd. Not only section 3rd, but it is also not defined in section 17 to 31. It is defined by the court Pakla Narayan Swami versus Emperor. Lord Atkin has defined the term confession. So according the question is which one of the following terms has not been defined? Has not been defined. Which option is correct? Which option is the best answer? So here A, B, C. These terms are well defined in the section 3rd of Indian Evidence Act, but the term confession is not defined in the section 3rd of Indian Evidence Act. So the best answer of the question shall be D. D is the best answer. Next, question number 23. Question number 23. Fact according to the Evidence Act means and includes. Fact according to the Evidence Act means and includes. It means what is included in the term fact. The first one, an existing thing. Only a mental condition of which a person is conscious. Only not but mental as well as material fact. The both type of fact is included in the term fact. So the answer A, B, it is not correct. Only a visible things, any tangible and visible things, and it includes statements, feelings, opinions, and state of mind. State of mind, opinions, these are mental fact, and these are here, from here, it includes statements, feelings, these are mental fact, and any tangible and visible thing, it is a material fact. It means the both term, material and mental fact, the both is included in the fact, and it is explained in the option D. So the best option shall be D. The correct option, the correct answer of the question, D. Correct answer of the question shall be D. Question number 24. The word facts does not include. The term fact does not include that a man feared in danger, that a man heard gunshot, perceived by our senses, perceived by senses. These are senses. that one man made and other man run. Sa. That the deceased has revealed the name of attacker. It means these are relating to our senses A, B and C. These are relating to our senses, but the option D does not relate to our sense. So the term here, the question is, the word facts does not include. Does not include. So what is not included? These are material fact A, B, C. Because it is perceived by our senses. So option D shall be correct answer, because the question is, the word facts does not include. So which of these things are not included in the term fact? The correct answer D of the question shall be D of the question. The deceased has revealed the name of. It means deceased has told the name of attackers who attacked upon him. So the best answer shall be D of the question. Question number 24. Question number 25. Any mental condition of which any person is conscious. Under section 3 of the Act, two types of facts are mentioned. The first one is material fact and the second one is mental fact. Material fact defined in section 3rd, that was anything. It means material fact includes anything, state of thing, relation of things of which is perceived our senses. These are material fact. But mental fact, any mental condition of which any person is conscious, any type of mental condition about which any person is conscious, that is mental fact. It means mental condition, mental fact is defined in the section 3rd of the Act. It is a mental fact. So it is a fact, but mental fact is fact. It is not. The true answer shall be B. Is a fact. Is a fact. Okay? Next. Question number 26. That a man has certain reputation. If it is said, Mr. X has a reputation, it is a fact. In the section 3rd fact is defined an illustration of section 3rd, it is also mentioned that reputation is a fact. So, reputation is a fact. This is true. Answer A option is correct. A option is correct. Option A is correct. It means it is a fact. It is a fact. Question number 26. After that, question number 27. Which of the following are fact? Harry said. Said, it means senses are used. Said. Saw, here is also senses. Ram lied. It means Ram told a lie. Ram lied. It is also described under perceived by senses. So all these A, B, C, these are relating to perceived by senses. So all these are facts. So correct answer shall be D. All the above shall be regarded as a fact, because perceived by senses, they are perceived by senses, and when anything, state of thing, relation of thing perceived by senses, that fact shall be called material fact. So all the above, this is the correct answer. This is the correct answer. Next, question number 28. The witness gave details of the objects in evidence in the court. What? This one adorned the room. It means the room was adorned. By which the room was adorned, it was explained by the witness in the court. So, what type of statement shall be regarded as a fact? So if a witness gives details in the court about the adornment of the room, it means it is a fact. It is a fact. Because if any room is adorned, material things shall be used. And material things generally are regarded as a material fact. So, if witness appears before the court and explains about the adornment of the room, so it shall be a fact. The correct answer of the question 28 shall be A. A is the correct answer because it is a fact. Okay, question number 29. Next question. A beats B to death. Following not relevant. It means from A to D what are mentioned. Which option is not relevant? Which option is incorrect or correct? आइए, come on, study the question A beats B to death, following not relevant. His motive to kill B. His intention to kill B. Motive, mental condition. Intention is also mental condition. Intrude which hit B. It is also a fact. But his kinship with B, it shall not be relevant. It shall not be relevant because any fact shall be relevant. Any fact is relevant to another fact when from section 5 to section 55. That is, it means from section 6 to section 55, under which relevancy of the facts are propounded. If any of them, a fact is connected with another, that fact shall be called relevant. It means mental or any other way from section 6 to section 55, relevancy rules are propounded under which a fact is connected with another. If any fact is connected with another under the rules propounded in the second part from the section 6 to section 55, that fact shall be called relevant fact. So C is not relevant, and the best answer shall be C. Following not relevant. If A beats B to death, all these are relating to the mental condition, but C does not relate. So the best answer shall be C. A beats to death, option C, not relevant. It is not relevant. Next question, question number 30. Question number 30. What does it say? Electronic records. Electronic records are oral evidence. That is wrong. No evidence. It is wrong. Documentary evidence. Documentary evidence. Any electronic records shall be regarded documentary evidence. So it is correct. The best option shall be C of the question 30. It means electronic records shall be regarded as a documentary evidence, not oral or any other, but it shall be regarded documentary evidence. And next, okay, the questions are finished. So thank you a lot of you. Thank you a lot. And next, I will solve the questions in English also. So thank you, that's all.